Hello. There are differences between California and Texas, and I'm not talking about the people. People are people wherever you go. I'm talking about differences in the laws. If you don't believe me, try to open carry in California, and then try to open carry in Texas. Well, actually, I recommend you try to open carry in Texas first, and then try to open carry in California, because you might not have the same amount of freedom to leave the state after you try to open carry in California. They are doing construction. Great. Anyway, my point, because I do have a point. My point is that this difference in laws makes some things illegal in Texas that are not illegal in California. In California, so the First Amendment, because that's what I love to talk about, creates the floor. No state can be more restrictive than what the First Amendment allows when it comes to speech. That's your floor. A state can afford you more protections than what the First Amendment allows, but it can't afford you less. And so what all the states have done that I have looked at, as far as their First Amendments, with the exception of California, is they've basically applied the First Amendment principles to their state's free speech portions. So the floor and the ceiling are exactly the same. And that is my understanding, and I'm not a Texas attorney, so there might be nuances I'm unaware of. There might be big things I'm unaware of, but my understanding of Texas is that free speech in Texas is essentially identical to the First Amendment. There's no difference between the floor of the First Amendment and the ceiling of the state protection of free speech. That's not the same as in California. In California's Constitution, there is protections for free speech. And California has so far resisted the temptation to switch over to the federal interpretation of free speech. And so the way California has interpreted the free speech clause in California's Constitution in regards to First Amendment activities in places open to the public is that the government can only restrict speech that is incompatible with the use of that facility, of that place that's open to the public. And the real world way that comes into play is in the analysis. When a federal court or a Texas court is looking at a restriction on, let's say, filming in a police station, they're going to look at it, is the limitation reasonable, and is it viewpoint neutral? And it just has to be reasonable. It doesn't have to be the least restrictive alternative. It doesn't have to be narrowly tailored. It just has to be reasonable and viewpoint neutral. In California, if a police station wants to restrict your filming, the filming has to be incompatible with the purpose of that police station, of that area that's open to the public. Incompatible. It means you can't have these two things in the same place. It interferes with the business. Because of that, you have a lot more protections in California than you do in Texas for your speech, because they're going to hit the ceiling of the California Constitution a long time before they hit the floor of the federal Constitution. A great example of that, in California courts ruled that First Amendment activities, free speech activities, politicking in a prison parking lot on prison grounds. The parking lot was intended for people to, come in to park and go in and visit the prisoners. But what people were doing is they were discussing unionizing activities and things like that with the prisoners who were coming out to clean the parking lot. And the California courts held that that was not incompatible with it. They rejected the Adderley v. Florida analysis, and they said, no, this activity isn't incompatible with this parking lot. Whereas in Texas, if you tried to engage in First Amendment protected activity in a prison parking lot, the restriction against you being there, against you filming there, would only have to be reasonable and viewpoint neutral. So that's a huge difference. There's another huge difference in trespass laws between California and Texas. In Texas, they have a trespass law. I mean, it is just easy peasy lemon squeezy. If someone with apparent authority, not actual authority, but even just apparent authority to tell you to GTFO, if that person tells you to GTFO, you got to GTFO. Now, if they're telling you to get the fuck out because they're trying to enforce a policy about filming, a policy about speech that violates the First Amendment, okay, then they can't tell you to get the fuck out for that particular reason. But if they could point to any other thing as the reason why they're telling you to get the fuck out, then they could at least make a good argument about why you have to get the fuck out. California, that's not so easy. If it is open to the public, if whatever it is open to the public, it is hard to trespass someone from there. Essentially in California, it's got to boil down to interfering with the business, with whatever's going on at that particular location, the intended purpose of that location. It has to be actual interference. It can't just be annoying. It has to be actual interference. So, for example, in California, a seminal case was where some people went into Leaflet to hand out flyers at the California State Fair. And they stood next to a tomato harvester, a tomato picker, and they were handing out these flyers. And fair security said, no, you can't do that. You're not permitted to do that. You need to get the fuck out. So they got out, but then they came back and they started doing it again. And they ended up getting arrested for trespassing, interfering. And the court said, no, they weren't actually interfering. There's no evidence to suggest that they were stopping people from going up and examining this tomato picker. There's no evidence that says that they were interfering with the people who were at the fairground, it's First Amendment analysis, interfering with the people who were wanting to see the tomato picker. Their speech wasn't interfering. That's not an actual interference. So the trespassing laws as well it's just really hard to trespass someone in California. They actually have to be for a government business, a government agency, libraries, schools. Well, schools have different, but libraries and police stations and things like that are open to the public, county and government, county and city offices that are open to the public. It's hard to trespass somebody. So California and Texas are different. And that's the underlying fundamental reason why I'm always pointing at Texas auditors and saying, you're actually not within your rights what you're doing. And I'm not doing that to California auditors nearly as often, because California auditors are generally within their rights. You have to fucking try. You've got to work at getting arrested in California for filming or for being an asshole while you're filming. You've got to work at it. In Texas, it's not nearly as hard. It's not nearly as hard. And, yeah. Well, anyway, my point is that I treat California auditors different from Texas auditors or from auditors from any other state because California is so fundamentally different in the laws, in the actual statutes, and in the Constitution, the California Constitution. It gives way more protection than the federal Constitution does. Way more protection. It is night and day. So things that are entirely illegal everywhere else, that or things that the state can restrict everywhere else, you're gonna see in California aren't restricted. The only other state that I've seen that I've actually looked at that's close to California is Illinois. Illinois provides a lot of protection as far as trespassing is concerned, but they allow, like, the cities will do a lot of laws that are more restrictive. But my point is, I'm at the court now, so I gotta wrap this up. But my point is that I treat people different based on the different statutes and constitutions that apply to them and what they're doing. But all told, I think it is a mistake for the auditors to make and for their fans to make to play favorites with auditors, to be on Team Earl or Team High Desert. That's a stupid thing to do. They're in different states. They're doing different things. I mean, it's not the government that is dividing people. It is people's natural tendency to want to divide themselves that's dividing people, and that's what's going on in this community. And I mean, everybody else hates auditors anyway. The public at large hates auditors. So if you guys start hating yourselves, I mean, what are you going to do? I have rambled enough. On my way back from court, I think I'm going to try to talk a little bit about Freeman and his attorney. So just if you see another video come up today, it'll probably be about Freeman and his attorney. Thanks for watching. Have a great day.